Hey guys, today we're going to talk about signing contracts without reading the contract itself and whether you can use it as a defense if you are sued. Well, I personally have witnessed many people signing contracts, 20, 30, 40-page contracts without reading the contract because the other party to the contract had explained and summarized it to the signing party and they sign it based on trust. Well, in business, there's no such thing as based on trust, okay? Now, as long as the four elements of contract formation are present, offer, acceptance, intention to create legal relations, and consideration, the contract is valid. So even if you sign a contract without reading the terms of the contract, you are bound by it. In the 1932 case of Lestrange and Krakow, the English court held that when a contract containing contractual terms is signed, then in the absence of fraud or misrepresentation, the party signing it is bound, and it's not important whether or not he has read the document. This principle was also espoused in the Malaysian case of Polygram Records, Sindirin Berhad, and the Search and Another. The Malaysian High Court held that when a contract is signed, then in the absence of fraud or misrepresentation, the party signing it is bound, and it is wholly immaterial whether he has read the contract or not. So, the law says that you cannot use the language barrier as an excuse. So the law doesn't care whether you speak Japanese, Teochew, Chinese, Italian, French. If the contract is in English and you signed it, you are bound by the contract regardless of what your primary or the only language you speak happens to be French or Chinese or Japanese. This general rule on language barriers was also found in the Malaysian case of Subrahmanyam and Ratnam. This was a dispute regarding a loan agreement. The defendant said he did not understand English, so he could not have understood the terms of the contract. In the court documents, he stated that the signing of the contract was a mistake and that he wants to escape from performing his obligations under the contract. The Malaysian High Court rejected this reason, and the court found him liable under the loan agreement. So, to summarize, a party has a duty to learn and know the contents of a contract before he signs it, and therefore a person who signs a contract is presumed to know its contents. I must mention that there is a defense called non-a factum, which renders a signed agreement void and unenforceable. This defense is commonly pleaded by desperate people trying to evade their obligations under the contract. But because of the very, very strict requirements, this defense is generally confined to cases where the defendant was unable to read the contract because of perhaps illiteracy, but there are further hurdles for the defendant to satisfy in order to persuade the court that this defense non-effectum can be made out. So, the take home for today is to read your contract line by line and understand the contents before signing it. So thanks for watching this video on not reading contracts.